Hello, welcome all. Welcome to the 10th program of Hammurabi INN Student. INN Student is a platform wherein law students come here and they show their research and they speak on the topic whichever they wish to like to give to us. Today, we are very privileged to call Bhairavee Shah from KES College, who would be speaking on the topic on cross border insolvency. Cross border insolvency is a very nice topic which every student which would be listening and getting more and more knowledge. Not wasting more time, I would like to call Bhairavee Shah and who would be giving us the guidance on this topic. Bhairavee.
Good evening everyone. My name is Bhairavee Shah. My topic for today is cross border insolvency. So what is cross border insolvency? Sometimes it is also known as international insolvency. It regulates the treatment of financially distressed debtors who have creditors or assets in more than one country. Typically, cross-border insolvency is more concerned with the insolvency of a corporate which operates in more than one country rather than the bankruptcy of individual. Cross-border insolvency focuses on three areas because more than one country is involved. Like these three areas are very important to determine. First is choice of law, second is jurisdiction rules, third is enforcement of judgment rules. However, the principal focus tends to be on the recognition of foreign officials and their powers. Now, the United Nations Commission on International Trade Law was established in 1966 as a subsidiary body of the UN General Assembly. The General Assembly recognized that differences in national trade laws regarding international trade were barriers to the effective flow of trade. So the purpose of UN CITRAL was to harmonize and unify the law of international trade. As a part of this program of harmonization, the UN CITRAL has developed a model law on the cross-border insolvency. Actually, the model law is not a law in its true sense. Rather, it provides, as the name suggests, a legal text for incorporation into national laws. The following circumstances necessitated the harmonization of legislation across nations with regards to cross-border insolvency. First is continuing global expansion of trade and investment. Second, increasing incidences of cross-border insolvency due to the integration of trade across different nations. Third is national insolvency law of different countries have not kept pace with the trend. Then fourth is inadequate and inharmonious legal approaches because every country has their own different insolvency law. So there is no coordination between the laws of different countries. So these were the reasons because of which they had to develop a model law. Now talking about India, India is a member of UN CITRAL and UN General Assembly, but it has not yet adopted the UN CITRAL model law on cross-border insolvency. However, the Insolvency and Bankruptcy Code of 2016 provides two solutions regarding the cross-border insolvency under Section 234 and Section 235. First, the government can enter into agreements with other countries to enforce the Insolvency and Bankruptcy Code. Second, the NCLT can issue the authority to write a letter, like a letter of request, to the courts and authorities of other countries to seek information or request action in relation to the assets of the debtors that are situated outside India. Now, as of now, there has been no attempts to stitch up any agreements with the foreign government. Also, in case of a bilateral agreement suggested by the code, it will be a very difficult and the lengthy process to negotiate an agreement with each and every country. And this will also create an ambiguity for Indian courts and NCLT to treat each case separately. Now, there are certain key provisions given under the model law. They are as follows. First is access. The provision relating to access give representatives of foreign insolvency proceeding and creditors a right of access to the courts of an domestic country and to authorize representative of local proceeding being conducted in the enacting country, that is the domestic country, to seek assistance elsewhere. Like, to give an example, in a cross-border insolvency between Australia and India, the excess is with respect to the representatives of Australian proceedings to Indian courts and vice versa. Second is recognition. These core provisions accord recognition to orders issued by a foreign court conducting a recognized or a qualified foreign proceeding, and having appointed the foreign representatives of such proceeding. We will talk about it at a later stage, that how do we recognize the foreign proceedings in our own country. Third is relief. The model law neither imports the consequences of foreign law into the insolvency system of the enacting state. Enacting state means the country which is enacting this model law, nor applies to the foreign proceedings the relief, like the remedies, that would be available under the law of the enacting state. Key elements of the relief also include interim relief, but that will be at the discretion of the court between the making of an application to recognize the foreign proceeding and the decision on that application. So between that time period, if the court wants, it may grant an interim relief to the foreign representative. Fourth is cooperation and coordination. These provisions address cooperation among the courts of the different countries, because as we know, more than 2 countries are involved in cross-border insolvency. There has to be cooperation among the different courts, where the debtors has assets in more than 1 country, and coordination of concurrent proceeding. Concurrent proceeding means more than 1 proceeding is taking place simultaneously, because the foreign representatives have filed for a proceeding in the domestic country, and the local creditors, the people, the creditors of that same country have also filed a claim against the same debtor. So these were some of the key provisions of model law. Now let us understand certain basic terms which are used in the model law. First is a foreign proceeding. What is a foreign proceeding? It means a collective judicial or administrative proceeding in a foreign state. It includes an interim proceeding, as we discussed above. In such a foreign proceeding, the assets and affairs of the debtors are subject to control and supervision by a foreign court. Second is foreign main proceeding. It means a foreign proceeding taking place in the state. Over here, the term state means a country that is enacting this model law, where the debtor has the center of main interest. So throughout the model law, determining the center of main interest is very important, because once the center of main interest is determined, only then a foreign main proceeding can be recognized. While the model law does not define the center of main interest, a debtor's registered office is presumed to be its center of main interest, but not always. Often companies are registered in jurisdiction depending on tax relaxation, etc. But the actual business is centered in some other jurisdiction. Third is foreign non-main proceeding. It means a foreign proceeding other than a foreign main proceeding, taking place in a state where the debtor has an establishment. Now this term establishment is being defined under the model law. It means any place of operations where the debtor carries out an economic activity with the help of human and goods or services. But such an economic activity should be for a longer period. It should not be on a temporary basis. Now, in cases where India is not a center of main interest, it needs to be ascertained if the corporate debtor has an establishment in India for recognition of proceeding in India as a non-main foreign proceeding. For non-main foreign proceeding, relief lies at the discretion of the domestic court. It should be noted that in the foreign main proceeding, the court does not have a discretion. Once the proceeding is recognized, the court has to mandatorily give a relief, but that is not the case in the non-main proceeding. Now, India, as we all know, has not adopted the model law, but legislation based on the model law has been adopted in 44 states across the globe in a total of 46 jurisdictions. Now a question arises, under what circumstances will the courts in Indian jurisdiction recognize the validity of foreign insolvency proceedings? Now in India, the method of enforcement of foreign orders is governed by section 44A and section 13 of the CPC 1908. A decision taken by an executive body or a quasi-judicial body shall not be treated as a foreign judgment and cannot be executed in the Indian courts. It should be noted that only the final awards or the final orders passed by the foreign courts are recognized in Indian courts. But however, insolvency orders, interim orders, administrative orders are not recognized for the purpose of execution in the Indian courts. It should be noted that the model law does not apply to entities such as banks, banking company, insurance company, because they have their own specific insolvency laws. Now there are a total of 32 articles given under the UN Citral model law, but I will be discussing only few of the important articles and giving their interpretation. First is principle of supremacy of international obligation. Now to the extent the model law conflicts with an obligation of a state, now that obligation is arising out of a treaty or an agreement to which the state is a party with one or more states. So in such a case of conflict, the requirements of the treaty shall prevail over the model law. Next article is Article 9, right of direct access. Now a foreign representative is entitled to apply directly to a court in the state enacting law. Foreign representative does not need to fulfill any formal or legalization requirements. Neither he has to obtain any license, that he is filing an application in an Indian court. He does not need to, obtain any license or go through a consular action, so that a quick action can be taken, and also such relaxations are provided so that, the debtor does not dispose of his assets and the creditors are left helpless. Now a foreign representative is a person, or it can be a body, appointed on an interim basis, authorized in a foreign proceeding to administer the reorganization or liquidation of the debtors. Like how we have insolvency professionals in India, the same function is to be performed by the foreign representatives. Next article is Article 11. A foreign representative is entitled to apply to commence a proceeding under the law of the enacting state. Law of the enacting state, not the model law relating to insolvency. He can do so without prior recognition of a foreign proceeding by a domestic country, by the state enacting the law. And this can be done in certain crucial cases, in the urgent need for preserving the assets of the debtors. Now let us take an example in a case involving cross-border insolvency between Canada and Japan. Now Japan over here is the enacting state. So Canada can file a application to commence a foreign proceeding under the domestic law of Japan. And like even though Japan has not yet recognized Canada's foreign proceeding, okay, still we can, the Canada's foreign representative can file a proceeding under the insolvency law of the Japanese court. Article 15, recognition of a foreign proceeding. The foreign representative may apply to the court for recognition of foreign proceeding. Such an application will be accompanied by a certified copy that a foreign proceeding has been initiated in our country, and this foreign representative is an authorized person to act on behalf of a court, or a certificate from the foreign court affirming the existence of the foreign representative and foreign proceeding. The court may require a translation, the Indian court or any other domestic court may require a translation of documents supplied in support of the application into an official language of the state. The model law presumes that such does not require any, that such a document need not be authenticated in any special way. the recognition of foreign proceedings in India will have to be made to the NCLT by the foreign representative, as the tribunal is not compelled to automatically recognize, like there is a process that we need to follow. Now, foreign main proceedings are granted recognition once the foreign representative satisfies the burden for proving where the center of main interest of a corporate debtor is located. Broad parameters for the use of discretionary powers of the tribunal in respect of granting moratorium. Moratorium is like a stay order in case of a foreign non-main proceeding need to be laid down in order to prevent an abuse of the power. Because as of now, like there are no, there is not, like they have not mentioned a list like what all powers does the NCLT have. Like it is completely at the discretion of the courts in the case of a non-main proceeding. Now, it is not a blanket rule that recognition is granted always. Rather, it is the discretionary power of the court or the tribunal. For instance, the US courts have been denied recognition on several occasions, such as in the case of SEC versus Stanford International Bank. SEC is their Securities Exchange Commission, like how we have SEBI in India. Now, the court is not compelled to recognize a proceeding unless the center of main interest has been proved. Moving on to the next article, Article 19. Relief that may be granted upon application for recognition of a foreign proceeding. From the time of filing of an application for recognition until the application is decided upon, the court may grant a provisional relief at the request of a foreign representative, and it shall include staying execution against the debtor's assets, granting a stay on local proceeding by the local creditors against the debtors undergoing insolvency. Second, entrusting the administration or realization of all or part of the debtor's assets in the hands of a foreign representative or any such person designated by the court. All these provisional reliefs are granted in order to preserve the value of the asset. Next is Article 20, Effects of Recognition. Now, what will happen once the proceeding is recognized? Once the foreign proceeding is recognized, the commencement or continuation of individual actions against the debtor's assets, rights, liabilities, obligation, etc. is stayed. Like there is a moratorium on that. The right to transfer, encumber means to create a charge on the assets of the debtor, or dispose, that is to sell off the assets of the debtors, is suspended. It should be noted that effects under Article 20 are not discretionary in nature. These flow automatically from recognition of the foreign main proceeding. So over here, the main thing is recognition of foreign main proceeding. The relief are also not the main part of the model law because it follows directly from the recognition. Now, automatic effects apply only to the main proceeding. Article 21. Relief that may be granted upon recognition of foreign proceeding, whether main or non-main, that does not matter. Now, it is similar to the provisions of Section 14 of the Insolvency and Bankruptcy Code. It also makes the recovery of the local assets of the debtors by the foreign representative very uncomplicated. Now, the extent of the relief is to be determined based on the principle of comity and assistance. Now, what is comity? In simple words, it means two countries accepting each other's law. Although the model law does not hinge on the need for reciprocity, this implies that if the model law is to be incorporated into Indian law, the Indian representatives, like the resolution professionals, cannot seek access to foreign insolvency proceeding of a state that has not adopted the model law. Nevertheless, a state that has not adopted the model law on insolvency can seek assistance from a country that has invoked model law. So the principle of reciprocity that has been included in the Insolvency Bankruptcy Code may however continue to exist even if India adopts the model law. Moving on to the next article, Article 28, which talks about concurrent proceedings. So after recognition of a foreign main proceeding, a proceeding under the law of the enacting state relating to insolvency may be commenced only if the debtors have assets in the state enacting model law. Article 28 in conjunction with Article 29 provides that recognition of a foreign main proceeding will not prevent the commencement of a local proceeding concerning the same debtor as long as the debtor has assets in the state. Like in simple words, like how foreign representative can file a proceeding against the debtor in the domestic law, even the domestic creditors are in the same position as the foreign representative. Next article is Article 32, rule of payment in concurrent proceeding. Now without prejudice to the secured claims, because of course they will get priority over the other creditors, a creditor who has received part payment in respect of its claim in a proceeding pursuant to a law relating to insolvency in a foreign state may not receive a payment for the same claim in a proceeding under the law of the enacting state relating to insolvency. Like twice you cannot get the same payment under the different law, but relating the proceeding is relating to the same debtor, so long as the payment to the other creditor of the same class is proportionately lesser than the payment the creditor has already received. So these were some of the important articles of UN Citral Model Law on cross-border insolvency. Now let us discuss about the UK exiting the European Union, the no deal effect, like the no Brexit effect on cross-border insolvency. Now currently the European Insolvency Regulation regulates European cross-border insolvency by prescribing the jurisdiction in which to commence insolvency proceeding and for their automatic recognition across other member state. Because as all the members are following this regulation, the insolvency proceedings in one state get easily recognized in the other state. They don't have to follow a certain procedure. Now this system streamlines the administration of insolvent estates throughout Europe and does so by relying upon mutual application by member states. Now in the event of a no deal Brexit, member states will no longer be compelled to apply the European Insolvency Regulation in relation to the United Kingdom, and so in a no deal scenario, insolvency proceedings commenced in the UK will no longer enjoy automatic recognition in the other member states. So to overcome this problem, in November 2018, the government adopted the Insolvency Amendment European Union Exit Regulation of 2018. The regulation provides for transitional agreements so that where proceeding have commenced before exit date, the provisions of the regulation will not apply. If the UK leaves the European Union with a no deal on cross-border insolvency, UK insolvency practitioners would have to incur some additional cost in having to make an application to individual countries. Prior to this, they all were the members of the, they all were following the European insolvency regulation. But now as UK might leave the Union, they will have to incur an additional cost because they will have to make a separate application for insolvency proceeding to each and every member state. So yeah, so are there any alternate options, for recognition? So the obvious starting point would be the UN Citral Model Law on cross-border insolvency, which has been also incorporated into the UK law through the Cross Boarder Insolvency Regulation 2006. Other member states would be able to take advantage of its provision in gaining recognition of insolvency proceeding in the UK. The outbound benefits for the UK are however limited. to date, the model law has only been adopted by 4 out of 27 member states. They are Greece, Poland, Romania and Slovenia, and none of which could be considered a key trading partner of the United Kingdom. So the model law is unlikely to, give or to offer much advantage unless and until all the member states adopt the model law in their legislation. Now, moving on, recently Singapore implemented the UN Citral model law on cross-border insolvency. The model law was finally implemented in Singapore on 23rd May 2017 through the Companies Amendment Act 2017. Now, what was the prior law? Like prior to the amendment, what was the law on cross-border insolvency? So we'll understand that with the help of a case law. The position in Singapore was articulated by the Court of Appeal in Beluga Chartering Company, which was under liquidation and others, versus Beluga Projects Limited. So in that, the Court of Appeal observed that Singapore courts were not bound to recognize any foreign proceeding, and whether or not a Singapore court would exercise its inherent jurisdiction to render assistance to foreign insolvency proceeding would depend on case-by-case basis. Means the providing assistance and recognizing the foreign proceedings was totally at the discretion of the court, because there was no a specific law to provide a remedy for the same. But under the amended law, recognition is largely a formalistic procedure, like how we saw under Article 15 of the model law, and generally upon an application being made by a foreign representative in the proper form, foreign insolvency proceeding will have to be mandatorily recognized. Coming back to India, let us understand the urgent need for a cross-border insolvency law in India with the bankruptcy proceedings of Nirav Modi's entities in the US. Even as the bank tasted their first success under the bankruptcy code through the resolution of Bhushan Steel, there is a gaping hole showing up in the bankruptcy code in resolving the matters relating to cross-border insolvency cases. Ever since the rupees 14,000 crore fraud at Punjab National Bank came to light, investigation agencies have been under a stress attempting to bring the alleged perpetrator Nirav Modi to book. Even as the agencies seized his assets and froze his accounts, Modi's overseas entities, there were 3 entities, one is 5-Star Diamond Incorporation, second is a JAF Incorporation, and third is a Fantasy Incorporation. So all these 3 entities in US have filed for bankruptcy, making it difficult for Indian lenders to proceed against the against his assets in the US. It was revealed that 5-Star Diamond Incorporation held inventory of polished diamonds worth rupees $3.8 million belonging to 5-Star International Private Limited. Now that country, the International Private Limited, is a country based in India with his majority shareholder as of course Nirav Modi. Now it soon became evident that the authorities in India would not be able to touch the assets of 5-Star International. Even though that company was based in India, Indian authorities could not do much about it. Importantly, unlike in India, where the bankruptcy code puts creditors in the possession of a debtor's assets, the US bankruptcy allows debtor to retain management and control the business. So he has absolutely taken the advantage of this lacuna, and this has raised concerns of a possible rushed sale by Nirav Modi of his business in the US. Although it should be noted that PNB has almost recovered approximately around 11,500 crores of rupees, but still there are a lot of lacunas in the present regulation on cross-border insolvency in our country. So due to this, the Indian creditors, the Indian lenders would not have access to the foreign assets of the company. The way Nirav Modi's entities for bankruptcy in the US ominously reveals the ingenious ways through which the Indian companies, through their multi-layered structures, can shift their cash and other assets to some other jurisdiction. Now this whole episode has brought to light the urgent need for a cross-border insolvency law in India. The Ministry of Corporate Affairs, the Government of India, invited suggestions on a draft chapter on cross-border insolvency. In this regard, the recent recommendation of the Insolvency Law Committee on cross-border insolvency marks a crucial step forward. The recommendations are essentially in line with the model law of the UN CITRAL on cross-border insolvency, but there are certain recommendations that needs to be reviewed. The definition of establishment as given in the model law may lead to the exclusion of internet-based companies that operate outside the traditional brick and mortar model, because establishment includes a place where the data carries on his economic activities with the help of humans and goods or services. So that does not include the internet-based companies. So also the center, while drawing out the list of indicative factors to help determine the center of main interest, will have to extensively draw lessons from the global experiences. After all, ascertaining the center of main interest will be critical to the working of cross-border insolvency law. But discretion is vested with the National Company Law Tribunal to draw its own conclusion under the proposed amendment. It also recommends that initially the model law may be adopted on a reciprocity basis in India. Legislative reciprocity, as we discussed earlier, indicates that a domestic court will recognize and enforce a foreign court's judgment and order only if foreign court has adopted the same. Given that our insolvency code is still evolving, a reciprocity is essential in protecting the interest of the domestic party. However, insolvency bankruptcy code is silent on position of a foreign creditor's right to approach NCLT to initiate corporate insolvency proceeding. However, the Honorable Supreme Court of India, in the case of Macquarie Bank Limited versus Shilpi Cable Technologies, set a precedent that foreign creditors shall have the same right as available to a domestic creditor. The Honorable Supreme Court expanded the definition of a person to include person residing outside India, just to give the foreign creditors a benefit. Also, I would like to mention that India was ranked 77th among 190 countries in the ease of doing business rankings by the World Bank in 2018 against 100 in 2017. Now, in the above pretext, the issue of cross-border insolvency possesses a serious challenge to India. There are inadequate provisions in the Indian common law regime to enable the Indian courts to recognize and enforce the rights and claims of the foreign creditors and the judgment passed by the courts in the foreign jurisdiction. Also, there will be several advantages which include greater confidence generation among foreign investors, enhanced foreign direct investment, adequate flexibility of seamless integration with the domestic insolvency law, and a robust mechanism for cooperation among at the international level. So, in the light of the above said circumstances, it has been strongly suggested that India should adopt the UN CITRAL model law on cross-border insolvency. So, that's it. I hope this article was informative and helpful, and I would like to thank Advocate Rahul sir for giving me this opportunity and letting me be a part of I-Enhanced student. Like, I'm very grateful to you, sir, and also I would like to thank Chirag for all the help that he has given me. So, thank you.
Thank you, Bhairavee. It was a nice, enlightening session. because the topic was cross border insolvency, something new. Even we, after 25 years, are also still searching on it. So we are really thankful to you for giving us such a nice lecture, and this is a small token from us to you.
Thank you, sir.
Yes.